We'll go ahead and get started. Excuse me for waiting a few minutes. We were working on some language in an instrument that there were two words spelled wrong in. It just takes a few minutes to get it straightened out, but it is. Call the meeting to order. All commissioners and the judge are present. We'll show that. If you will stand, please, for the opening prayer and remain standing for the pledge of allegiance. Our Heavenly Father, we're thankful for the many blessings that have been given to us through our lifetimes and in our county here. We appreciate the opportunity to serve the public and to do the things that need doing to show the outstanding county that we have available for our use, and only during the time which we're here, which is a short time of our life. I would pray that you look upon us every day as we make the effort to keep your kingdom in the same sense that it came to us in. And with that, ask that you bless each and every one of us. In Christ's name we pray. Amen.
Amen.
Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Good ship.
Let's put that one that should be on the podium. Because
You want to put one on the podium?
that's what it's for.
That's important.
So we have that one before those from over there. Because we want to always have problem with the water.
Our first item of business in this meeting will be the consideration of and approve or disapprove of Services Agreement Amendment Number 2 for the expansion of the Karnes County Residential Center with the GEO Group and the Intergovernmental Services Agreement, for instance, IGSA, close parentheses, with the U.S. Department of Homeland Security, Immigration, Customs and Enforcement, parentheses, ICE, close parentheses, period, authored by Jeffrey F. Chapman. Mr. Chapman, if you'll explain to us what this is about.
I will. When I was here last week, we had a discussion about the service agreement amendment number 2 between the county and GEO Group, and how that relates to the obligations that ICE and the federal government have with respect to the detention facility that's here in Karnes County and is the subject of the potential expansion. That is what this agreement covers. I'm not going to rehash everything that was discussed in that meeting, but I will remind you that at the end of that meeting, I was asked to negotiate a number of items with the GEO Group in order to improve the agreement and address some of the concerns the commissioners and the county had at the end of the last meeting. Those items that we were charged to discuss, that being the county and GEO, were the administrative fee that GEO was to pay to the county for the contract administration costs the county incurs in essentially processing paper and documents relating to the operation of the facility. The additional indemnity language which we discussed to make sure that GEO paid for any costs the county might incur as a result of either lawsuits that arose out of the operation of the facility or costs for other expenses and fees the county might pay or incur as a result of its involvement with GEO's operation of the facility. We were asked to negotiate language relating to costs or control of the release of detainees into Karnes County. We were asked to look into the regulation or enforcement of standards that are incorporated into the agreement relating to staffing and the obligations GEO has with respect to their staffing obligations at the facility. Also, I was asked to see if we could negotiate a release out provision of the obligations that the county has with respect to, specifically with respect to provision paragraph number 3.04, which is a provision that really brings us here today, which requires the county under the original agreement to cooperate with and execute agreements that GEO might present to the county in the furtherance of the operation of the facility. And also, GEO asked me to discuss one additional provision which was raised in our meeting the day following the last Commissioners Court meeting, which was an acknowledgement that the county judge may sign administrative documents that don't affect the scope or the responsibilities under the agreement, but would allow for the facilitation and operation of the facility, much the same as the work that we have to do with respect to the administration and the administrative fee. This would be an authorization or an acknowledgement that these things do have to get signed in the operation of the facility. So we met with representatives from GEO and negotiated those terms. I'm here to explain to you what we've done to the agreement that is different from what you had before you last week. Also to address some of those concerns and answer any questions that you might have with me with respect to the county's obligations and liabilities or potential liabilities going forward with respect to the facility. So let me begin with the administrative fee. We've negotiated for an increase in the administrative fee to be paid to the county from $100,000 to $125,000. Just so y'all know, the administrative fee is regulated by federal regulations, and it's not intended, nor is it allowed under those regulations, to be a profit center for the county, because it's money that comes essentially directly from the federal government to the county. It's intended and regulated by the federal government to only compensate you for reasonably anticipated costs that you will incur in the administration and furtherance of the operation of the facility. Because the county has already expressed the need for hiring a business operations person to assist with the contract administration and the processing of the necessary documents which are required in the operation of this facility, we felt like it was appropriate and the county could justify the costs associated with a portion of that person's salary to be added to the already negotiated administrative fee, and therefore we were able to raise that fee from $100,000 to $125,000 as a payment from GEO to the county. That should help the county offset the actual costs it will incur in administering its obligations under this contract. The second item which we negotiated was the indemnity provision. In the indemnity provision, the thing that we were concerned about after the last meeting, and also as a result of some of the comments that were received from the public before my presentation and our discussion last time, was potential exposure the county might have with respect to lawsuits and litigation that could be filed as a result of civil rights claimants and people detainees who are housed in the facility complaining of either their treatment or merely the fact that they are being detained. The county, of course, isn't involved with the operations of the facility. The county is not involved with handling or processing or detaining those individuals, nor is it involved with the release of those individuals. However, because the property, the facility is in Karnes County, it's likely that Karnes County will be named as a defendant in some of those lawsuits. Of course, the county doesn't want to incur costs in defending those, and the indemnity agreement which we've negotiated is broadly worded so that GEO acknowledges and will pay any and all liabilities the county might incur in dealing with those lawsuits. It has language in it which obliges GEO to defend the county, which means that the county shouldn't even have to hire a lawyer to defend it. It should simply send a notice of indemnity obligations to GEO, and under this agreement, GEO is obliged to honor that and to pay for the defense of the county and hold the county harmless in any of those actions. I've added into the indemnity agreement based on our negotiations a clear notice provision which is triggered merely by the county giving written notice to GEO of that obligation being triggered. And I've also negotiated in there with GS% language which would broaden the expanse of the indemnity to cover any costs and fees or expenses, including legal fees, that the county might incur in securing the performance of those indemnity obligations, or in securing the advisement and professional assistance, such as my time here today, my time dealing with this issue for the county, so that the county has, if the county incurs professional fees and legal fees in dealing with this agreement and honoring its obligations or assessing its obligation under this agreement, GEO would indemnify the county for those costs. It's the broadest language we could negotiate to make sure that the county was fully insulated from any potential liability on that regard. The next item we negotiated, or attempted to negotiate, was language relating to the release of detainees and costs that might be incurred by the county if detainees were released in Karnes County. And unfortunately, we're unable to put into the agreement any language that addresses this particular concern. Part of the problem, which I think we discussed last time, was that this is largely governed, in fact, it's wholly governed by federal policy. And while we don't know how the federal policy will be administered by the federal government, nor do we know what future federal policy will become, we have no ability as a county to regulate what the federal government might do with respect to the Department of Homeland Security and ICE. And therefore, there is no agreement that we can put into this contract which would prevent GEO from following federal policy and releasing detainees if, in fact, the federal government were to issue an order which authorized and requires the mass release of detainees who are currently in the facility. However, because I couldn't negotiate that for the county because it is tied to federal policy, I did ask GEO to provide me with some information and statistics which would help the commissioners evaluate the risk of that actually happening. And looking at statistics that GEO has provided, which they received from ICE as a result, as it relates to their facility, when one of these facilities has been closed, and that has happened, there was a facility that was closed in New Mexico, the detainees were not released en masse into the community where that facility was. That facility was the Artesia facility, and it closed. Those detainees who were housed were moved to other ICE facilities. The statistics which relate specifically to the release of detainees from the Karnes County facility are that since August, the average stay in the facility has been roughly 50 days, 49 and a half days. There have been 1,003 arrivals, there have been 657 releases. Now, the release statistics show that of those detainees who've been released, the 657, 19 have been released to other ICE facilities elsewhere in the United States. 115 have been deported. 521 have bonded out, which means they've been sponsored by a family or individual who's paid for a bond which would allow them to be released from the facility while the administrative process is ongoing through the Department of Homeland Security for their asylum request. Those people, the 521 people who've bonded out, none of them have stayed in Karnes County. And in fact, the statistics that I've seen, and I have not independently verified these to be true, but I've seen them and they've been provided by GEO, almost none of those 521 have actually stayed in Texas. So I don't think that, based on what I'm hearing from GEO and looking at the statistics from the Department of Homeland Security, there is a significant risk that the facility will open and this county will be flooded with obligations for Health and Human Services with respect to the people who are currently housed there. And of course, that's a risk that we simply can't really anticipate or contract around because, as I said, it relates solely to federal policy. So if this facility is allowed to expand, and if this facility stays in Karnes County and is maintained and open and operated by ICE, that's something that ICE governs. The county really has no jurisdiction or ability to govern or to police that occurrence from happening. And so that language wasn't inserted into the agreement as was requested that we attempt to do so. The other language that we were asked to look at was staffing obligations. because there was significant concern that was raised in the meeting last time about whether GEO understaffs the facility, whether GEO takes proper care of the detainees who are housed there. We were able to negotiate language which I put into the agreement, and it's an additional language to what's already there. As I mentioned last time, the standards and regulations that are promulgated by ICE governing the staffing of these facilities has been incorporated into the agreement from previous amendments. And that was not a question that was raised last time. Those do apply, those are binding on GEO. GEO is obligated to follow the staffing requirements and guidelines that ICE provides. The problem that was addressed last time we met was that the county had no independent ability to verify the level of staffing at the facility, nor did the county have any ability to police that. And the request was made that we negotiate some language which would address those concerns so that we could, as a county, ensure that a facility located in our jurisdiction would be properly staffed, and that to the extent those regulations are required, GEO follows those to make sure that the people who are staying at that facility have adequate staffing to support the level of the population there. What I've done in the agreement is I've added the ability of the county at its own discretion and its own authority and capacity to request and to oblige GEO to provide the county information with respect to current staffing levels at the facility. And this allows the county to both go into the facility physically and also to audit the books that GEO has, showing the level of staffing that GEO has at the facility to make sure that it is in fact compliant with the regulations that the federal government has laid out. Now, the county doesn't necessarily need to or want the obligation to police that. The county has no authority to fine GEO or to otherwise order GEO to comply with those regulations because they are federal in nature. However, I was able to negotiate into the agreement provisions which would allow the county the unfettered ability to report any discrepancies, irregularities, or concerns about staffing it has to both GEO and ICE, to ensure that if there are concerns that the county has after going to the facility and reviewing the staffing levels of the facility, that the county has the opportunity to essentially police those regulations without actually having the authority to issue penalties or to follow with any kind of enforcement action, because like I said, that's a federal question. But it does give the county the contractual right to make sure that the staffing levels are appropriate based on the regulations that are promulgated by the federal government. The final clause that the commissioners were asked about was the termination date or an early expiration date of the contract, specifically with respect to section 3.04. GEO is unwilling to do that. GEO has already in the contract the termination date. The county has negotiated with GEO a 30-year term to this contract. The contract was signed and executed in 1998. So the contract as it currently stands expires in 2028. There's 13 years left on this contract before it expires. There are no renewal terms in the contract agreement. There's no obligation that the county would have to agree to any type of renewal term. If the facility is still in operation in 13 years, or even if just a correctional facility is still in operation in 13 years and the county wishes to maintain its operation, they'll have to enter into a new agreement governing that occurrence. At that time, if the county wants to remove the language that's in 3.04, it can do so under any kind of contract agreement y'all will agree to. The reason GEO, if I may paraphrase what they told me in our meeting, is unwilling to shorten essentially the termination clause of this contract is that by expanding this facility, they're investing $37 million into Karnes County, and they are unwilling to shorten their amortization schedule as far as their recovery of those costs and also the benefit they expect to derive from that investment. That was simply a non-starter for them. I asked and we weren't able to get it. The thing the commissioners can note is that, of course, that we do have a termination clause in the contract that's built into it that it terminates in 13 years. And at that point, you're free to do whatever you wish to with respect to the facility in place. Those are the terms you asked me to negotiate. That's the result of those negotiations. GEO did ask for an acknowledgement that the county judge can sign administrative documents which do not further bind or affect the county's contract with GEO. And we put a whereas clause in the beginning of the document which simply states just that. It acknowledged that in furtherance of the operations of the center or the facility, that administrative documents must be executed by the county, and that those documents do not affect the obligations contained in the agreement, but they are necessary act between GEO and ICE. To the extent that 3.04 exists, to the extent that this acknowledgement is in the contract, much like the business operations person's responsibility with respect to administrative paperwork and operating the facility, this agreement now acknowledges that there are certain items the county has to sign, but they're not agreements. They're not binding on the county, which of course is the reason for the discrepancy and the concerns about section 3.04, that provision does in fact oblige the county to sign agreements which would be binding on the county. This acknowledgement does not do that, so I put in the contract at the request of GEO to allow the county judge, based on the acknowledgement and authorization of this agreement, should you choose to authorize it, to allow the county judge to sign those documents if needed without having to come back to the Commissioner's Court for these meetings anytime there's an administrative document that needs to be signed. That's the extent of the modifications to the agreement based on what you have asked me to do. And I will reiterate from my comments last time that my analysis of the immunity issues and your potential liability has not changed. With this agreement, you have now before you two options. You can either approve the agreement and move forward, or you can reject the agreement and not sign it. If you approve the agreement, the indemnity clause that we've negotiated fully protects the county from any potential liability for lawsuits or costs that would arise as a result of GEO's operation of the facility. I don't anticipate, and I have not foreseen in my analysis of this agreement, any situation where there could be a lawsuit or a claim filed or a cause of action that would arise to anybody relating to the operation of the facility, whereby the county would be liable or the county would have to incur any expenses in defense of those claims. This indemnity protects the county from any of those potential liabilities. The other liability issue would be if the county chooses not to sign the agreement. If you choose not to sign the agreement, you are in breach of section 3.04 as it's written in the original agreement. If you don't cooperate and sign this amendment number 2, then you will prevent GEO from expanding the facility because you won't have agreed to allow that to happen. You will not, in and of itself, prevent the operation of the existing facility because the underlying agreements would still be in place unless they were terminated by future action. That would be an action that GEO might contemplate if it considers your failure to sign this service agreement a material breach of your contract obligations. However, even though the legislature has waived your immunity from lawsuits in Chapter 271 of the Local Government Code, as I said last time, the only damages that GEO could possibly incur as a result of the county not signing this amendment are consequential in nature, and they are specifically prohibited from recovery by that statute. This is, in its essence, a contract which gives GEO permission to operate a facility in Karnes County. That in and of itself doesn't waive immunity. But in that contract, the county receives a service of allowing 30 beds for inmates at the facility, or for the correctional facility. That's a service that they provide to you, but this county does not pay for that. In fact, it says specifically in the contract, the county owes GEO no money for that. It's a no-cost obligation. The only obligation the county has would be for medical care for those inmates in those 30 beds. If you breach the contract and not sign this amendment, Chapter 271-152 says that you would only owe, or it's actually section 153, it says that you would only owe damages for the balance left due and owing on the contract. Under this agreement, there is zero balance left due and owing. In fact, there's zero money that goes from the county to GEO. So there would be no liability to the county for money damages if you didn't allow this. But if you did not allow it, what GEO would like me to point out to you is that you would be removing from the property tax rolls and the tax revenue of the county, what they estimate to be an additional $500,000 in tax revenue that you would receive from this facility. Now, I don't know where those numbers came from other than they were shown to me by the jail representative, so I don't know, have not independently verified that calculation, nor do I know the time frame in which the county receives that benefit. But that's the number they've given. You'd also be losing the $125,000 administrative fee that they're paying under the agreement. So those are the considerations I think the commissioners needs to take into account with respect to liability and what your chosen course of action is today. That concludes my prepared remarks. If you have any questions, I'm happy to answer them.
Yes, I have a question. The first one referred to the judge's permission to sign the contract. Didn't we already have that?
3.04, yes, 3.04 applies to the county to sign those, and as part of the administrative agreement, the county has to sign those. This was put in there simply as a matter of caution to make sure that there's an acknowledgement in this agreement. Now, this agreement and the location of that clause is in the preamble provisions of this agreement. It's not an actual section of the agreement which creates an obligation on the county. The obligation is created by the underlying 3.04. It's merely an acknowledgement that there are administrative documents that are required that do not affect the obligations of either GEO or the county.
All right, I'm familiar because I've talked to a man named Mark Castellano or somebody who worked in DC, referred to some of these and consulted with the judge.
Right. And I think those types of agreements, the task orders and the other documents that come from ICE to GEO that require the county signature, those are the documents that are anticipated to be subject to this acknowledgement.
Jeffrey.
All right,
I'm sorry, go ahead.
Regarding section 304, Ms. Amber Martin came to us a few weeks ago and told us that we could be sued for breach of contract. Now, if we can't be sued for any money, why do they insist that this 304 stay in there? I feel like it's a threat. It's not a good neighbor to have a threat that I can sue you if you don't do what I say. That doesn't sound very good to me.
Well, I can't speak for them as to why they would want it to be in there, other than because I think it provides them security that if they need an agreement between them and ICE that requires the county signature, they've got this provision which obliges the county to sign it. It allows them to conduct their business in this county. And I don't dispute what Ms. Martin said as far as the county being subject to a lawsuit. Like I said, you have waived your immunity by signing the contract, but there's no damages. So if you were sued, a simple plea to the jurisdiction would, based on current and controlling Texas law, entitle you to a dismissal of that lawsuit. And as far as being, neighborly and having a good relationship with the people with whom you contract, unfortunately, in the law in Texas is that you negotiate at arm's length, and you do what's in the best interest of your party and your county, and they will do what's in the best interest for their company. And if we don't like it, then we can choose not to negotiate with them or not enter into any other agreements with them. This agreement, unfortunately, for what it may be, was negotiated back in '98 by a prior commissioner's court. And I know that, from talking to the commissioner's court and being at the meetings and listening to your comments, you feel like you've had your hands tied by this agreement and you don't like it. And I can appreciate that. The fact of the matter is we are all here today dealing with the document that's been in effect for many years now, which none of us were involved with when it was signed. And I think it can be a lesson that we don't enter into these types of agreements in the future. But with respect to what your current obligations are, all I'm here to tell you is that under this agreement, you do have a contractual obligation to sign that, which may subject you to a lawsuit, although that lawsuit would be fairly painless since they have no teeth to enforce any dollar damages.
I have one other question. These 30 beds that we have out here, they have to keep this facility in compliance with the Texas Jail Commission. At one time during the past 4 years, I do know that they were not in compliance, and we had to transport all of our inmates to Pearsall or someplace at our expense because they were not in compliance. We couldn't put any of our inmates out here. Is that possible to let it happen again?
Well, I think that the indemnity provision that we've negotiated now is broader than the one that was in place before, and you would have a right to indemnity for any costs that you incur as a result of their operation of the facility. To the extent that the detention facility and the correctional facility are all part of the center, part of the facility, if you incur costs as a result of their operation, and their operation would be a non-compliance issue with the jail standards, you could notify them that you have the right to be indemnified for any costs you incurred in transporting and housing those inmates elsewhere until they became compliant with whatever standards they were not in compliance with.
You feel that that is covered in this section 5?
It's in section 3.05, and the language has been broadened to say that GEO indemnifies the county from any claims, causes of action, liabilities, suits, prosecutions, administrative actions, costs, expenses, and fees arising from, related to, or caused in whole or in part by the operation, occupancy, expansion, or use of the facility or the center. Now, the thing that wasn't there previously was costs, expenses, and fees. The previous language was written in a way that was intended and read to only indemnify you in the event there was a lawsuit or a cause of action or a claim filed. This language is written in a way that you are now indemnified for any costs you incur as a result of their operation of the facility. And yes, I do believe that in this situation you just presented, this clause would provide you the right to indemnification from GEO for those costs.
You asked a lot of good questions, thank you. I have one under section 3.03. The original agreement was 30 years, right? Termination was 2028?
Yes.
Okay. Right here it says GEO shall continue to make available to the county up to 30 beds for the housing the county inmates in the facility by GEO for the life of this agreement. Okay. That doesn't mean that they're terminated in 2028. That we still have them from now forever, right?
You have them until the agreement expires in 2028. You have 30 beds for as long as the agreement is in place. This provision here in section 3.03 is merely a restatement and acknowledgement of what you had previously negotiated, which was originally 15 beds and now it's expanded to 30 beds. And this restates that. But this does terminate at the time the agreement terminates in 2028 unless it's extended.
Okay, and I'm sorry, I was thinking that we were going to have the 30 beds for good.
The 30 beds lasts with respect to GEO as long as GEO runs that facility.
Right.
Now, if you have someone else run that facility that in a different contract, then you can negotiate at that time for the same level of capacity once you renegotiate or enter into a different contract. But GEO's obligations to the county and GEO's rights to run that facility terminate in 2028 unless it's extended. And so the 30 bed provision, the service you get from GEO for that operation terminates when their rights terminate. Yes.
Then we can renew.
You can renew, you can renegotiate, you can hire someone else, you can run it yourself, or you can close it.
Okay, I understand. One other question right here under section 403, where it says GEO will pay annually $125,000 for administrative fees. That's regulated by the federal government, right?
Yes, what's allowed to be included in the administrative fee is regulated by the federal government. The estimate and the actual costs are ours to determine. But as I said, it's intended only that the federal government reimburse the county for actual costs. And so it can't be a profit center for the county. The county can't come in and with any justification as to what it might spend to administer, say we would like $250,000 a year. So we felt like the $100,000 amount that was originally negotiated was supportable by our actual costs in helping administer that. Because we've acknowledged the need for additional support staff in the county, we allocated a portion of that additional support staff's costs, essentially our overhead, to this agreement, and that's why we were able to raise the cost from 100 to 125.
Okay. And even though there's a cost of living per year, you feel that 125 will cover for the next 13 years, every year?
Well, it's not intended to be adjusted, but if that's something that we need to discuss with GA before we sign this agreement, we can do that.
I'm not trying to prolong it in any way. I'm just saying, what if it goes in 5 years, it jumps up to, our cost is 140, and we're limited to 125 here.
If that's the case, then we need to renegotiate the provision. I didn't do any independent calculations. We only looked at the data we have available to us now, because that's the way we chose to do the calculation. And the 125, if we have additional support staff come on and they receive salary plus benefits for total compensation of approximately $50,000 a year, we felt like we could justify 50% of that person's role with this county as an additional administrative fee. We didn't go into a significant level of number crunching with regards to financial projections. I don't have an expertise. I don't think it does.
That's all I have.
Mr. Chapman, I have one question. You say the contract is tied to the 30 years tied to the 1998, correct?
Yes.
Then, does it affect any other construction that has come online after 1998? Does that 30-year push forward, like say they need to build something today?
No, it only applies for 30 years.
Okay.
If they build this facility tomorrow and they come back to us in 3 years and say they want to expand it another 300 beds, it's still 30 years from 1998. We're not amending in any way the term of the contract.
I don't have any questions.
I have one question. How will the county recover the administrative
Wait.
fees?
This is a meeting of the board, of the commissioners court, and you're not part of the court,
Okay.
so please don't answer.
Okay.
If the court member wants to ask it, fine.
Well, Ben, it was asked. You got a response.
I'd say that's a matter of internal record keeping and bookkeeping for the county as far as how that's recovered. I don't know the inner workings of the relationship between GO and the county and how you invoice them for those fees or how you handle and process the paperwork. But the agreement anticipates, and if obliges them to pay it, it's up to the county to request it. And if that be a simple letter, it'd be a simple letter. If it's some other support or justification, then that's what you would do, is based on your own internal policies. There's no obligation on the county to provide any specific information to GO with respect to that amount of money. It's merely a request that they pay it and they have obliged and are supposed to pay it.
I have looked at this agreement and it's that thick, and I don't pay. I won't claim that I have put garbage on because I haven't. But best I recall, it had, this is for up to 2,000 persons. Does that include the 1,200 there, the 500 at the other facility? That would be 1,700 and 300. Is that the limit of this contract, or would you?
Well, this contract right now is only to expand the detention facility to 1,200 beds. And it doesn't expand the correctional facility at all. So the total number of potential beds that would be in those facilities would be whatever's in the correctional facility right now, plus the existing 600 beds at the detention facility, and then an additional 600 beds. I believe in an earlier iteration of this agreement, the number 2,000 was in here, but it now says 1,200. And so if we sign this agreement, it authorizes the expansion of the existing detention facility from 600 to 1,200 and no more.
Okay, so my basic question is, if GO comes back in 3 years or 5 years and they say, we want to build an additional 5,000 facilities, do we have to sign it, or we compelled to this company?
Unfortunately, if they came back and they had the IGSA worked out with ICE, and there was an agreement that ICE had entered into with GO to put that many detainees in this facility, and GO wanted to build it here, as long as they've still got the underlying agreement in place until 2028, Section 3.04 would oblige you to go through this process again and to consider signing it.
So we'd be here again.
You would be here again. You will be here again if it happens until 2028
Because of that.
because of the original agreement.
Which was placed in 1998.
Yes.
Nobody else have anything? Well, under all the circumstances, and I took everything in consideration, and I know that we've heard from a lot of people, not from the county and from the county. We've heard from the employees from GEO. I've heard from the county employees. Believe me, I've got an earful every day since all this started. But Jeffrey did, thank you. You did a good job on everything that we asked for. The only thing that I would ask is this on this 125, if we agree with it, can we place there plus the cost of living now, or does it have to be renegotiated?
I would have to ask the GEO folks who are here today if they want to comment now. They can. If you want to have me speak to them after this, I can do that. If they're amenable to doing that, then if the Commissioners Court chooses to authorize this agreement with that amendment, that motion can be heard, and if that language is put into the agreement, we can authorize it without having to come back to a separate special meeting.
Judge, can they speak?
I'll allow them to speak about that.
If the county were to enter a cost of living increase on the $125,000, which would be unfortunately revenue commission.
Annually?
With that said, I could put into the agreement language which would state that the administrative fee would be $125,000, subject to an annual cost of living adjustment to be negotiated by the parties. If that language is agreeable to the commissioners, it sounds like it's agreeable to GEO. If this agreement were to pass with that modification as part of the motion, we can do that without having to come back for a separate meeting.
Okay, ladies and gentlemen, I appreciate everything, all the comments, good, bad, both ways from everyone. I really do appreciate it. It opened our eyes on a lot of things that we didn't know about, and I really appreciate it. But I have to vote the way I think I should vote today, and I'm going to make the motion to approve expansion of the jail of the high school.
Second.
Been a motion and a second.
With all the provisions,
Is this item 6 or 7? I thought we were
number 5.
on 5.
James, your motion included the,
All the provisions
And,
that Jeffrey Chapman put in there.
and with the addition of the cost of living.
Yes, with that in there too.
Any other comments or motions? Pete?
Still don't like me living the threat hanging over my head about it. Being right to sue us is a good neighbor.
Anybody else on the court?
I have no comment.
And there is a motion and a second that we approve the contract amendment with the additional matters that we've discussed here. That'll be part of the record. All in favor of that motion signify by raising your right hand. All opposed, 3 for, all opposed, same sign. 2 opposed, motion carries 3-2.
Thank you, Mr. Chairman.
Thank you very much. Yeah.
Thank you all very much for all y'all's attendance.
If there's anybody who wants to leave, please feel free to do so.
The next item on the agenda for the meeting today is item 6, and this concerns information for Mr. Chapman also. Presentation, discussion, and possible action to approve the use of job order contracting for road and bridge operations and maintenance annual improvements program, and that's authored by Jeffrey S. Chapman. Jim.
All right, thank y'all. Let's move to a less contentious issue.
There you go.
Well, we don't know yet.
Well, we hope it is. I was approached by Road and Bridge and by your county attorney because there were some concerns about how we were spending our road maintenance budget, how we may be subject to potential liability for any kind of injuries or accidents which might occur during the course of those operations. What had been happening and what is currently happening in the county with respect to that work is Road and Bridge, because we don't have enough equipment and facilities to handle all the maintenance operations with our own personnel, Road and Bridge has been contracting with, basically using purchase orders, road contractors to provide maintenance for county roads and other, infrastructure. And that's perfectly fine. It was authorized at some point by the county commissioner's court to allow that to happen. The concern was raised that when we use those types of purchase orders, it's merely a one-page invoice that lists the type of equipment that's being utilized, the rates for any kind of equipment and labor associated with that, and then it's a payment obligation. So the county was essentially soliciting the lowest bid information from these various contractors, hiring them on an as-needed basis for a daily rate essentially, which is depending on how long they're out there, a few hundred to a couple $1,000s. But if something should happen, if the operation of a crusher or something would get someone get injured, there's potential concern for liability on the county's behalf. So I was approached and discussed this with Road and Bridge and with the county judge and county attorney, and we felt like it was worthy of bringing it to the commissioner's court's attention because there is a mechanism that we can use in creating a contract form that we would use after soliciting bid information from various suppliers or contractors to allow us to make sure that we have contractors working for us that have the appropriate levels of insurance coverage, the appropriate payment terms are there, and that we know as a county that this operation is not only authorized for Road and Bridge, but also that the commissioners court have essentially policed the agreements and made sure that we're getting the best value for the services that we're contracting for. In the government code, there is a provision, a type of contracting method called the job order contracting method. Now that's envisioned in that code to be used for expenditures over $50,000 for building maintenance. And we're talking about road maintenance. Now there's a specific exception to the use of that particular provision in road work because of the political dispute that goes back about a dozen years between Governor Perry and the engineers law. So we can't use that method. But the good news is we don't need to because we're not talking about expenditures that are in excess of $50,000. Technically, we are under any limit or requirement for this work for publicly bidding the work. However, it's still within the county's best interest to make sure that we get the best price and we solicit the lowest price from available qualified contractors. So what I'm suggesting in order to make sure that going forward the county's concerns about liability and pricing structure are complied with is that we solicit a pre-qualification process for contractors who can provide the service to us And in that pre-qualification process, we would issue an advertisement for a request for qualifications. We'd receive this along with pricing information from contractors who can provide these services to us, and then enter into, or have at our disposal, a pre-approved contract with the appropriate levels of insurance and bonding and liability risk on the contractor, so that the county can't be exposed to potential damages or personal injury or property damage that would occur as a result of county order and county administered work of this nature. It would also ensure that Road and Bridge has the proper authority and delegation of authority by the commissioners to Road and Bridge to enter into these contracts, so long as we're not entering into one that is the value of higher than $50,000, because as you know, any contract in excess of $50,000 should be individually bid. We wouldn't be entering into a true job order contract because it wouldn't be a contract that would be signed by the county and a contractor for jobs to be ordered at any given time. But we could have it a pre-qualification process for up to a year, so that the commissioners could revisit this issue next year and either extend the approval or rebid if they felt like prices were either going up or down, based on the availability of machinery and work in the county. A lot of that is in oil play and how that affects the construction economy and construction market around here. But it's something that I was asked to address with you, and that's my recommendation, would be that the county solicit requests for qualifications to pre-qualify a handful of contractors, so that Road and Bridge would have essentially in its stable a list of contractors with whom had already agreed to our terms, who would be essentially on call dependent upon availability to perform this work for us, while using terms that we've already approved to govern, insurance, and we can maintain records of that and make sure the county is adequately protected. The risk, I think, that is perceived right now is that there's not an adequate level of protection in the use of these 80 dump trucks a day who come bringing material, and the graders and the other iron being used on our roadway. So that's the recommendation. This is a discussion item, so any questions y'all have about how the process would work or how we would go through, I'm happy to answer. If you'd like to take an action, we can entertain a motion from the floor. Right here at your disposal.
The contract, is it just per project? Would be per project, because, some roads, then they can work on, like you have one contractor, he may have 5 roads that he's working on that total over $50,000.
It would be a per location, per job order type issue. And that's the way they're doing it now. It's I need work on county road, whatever. This particular location needs whatever service or maintenance, and so Road and Bridge calls them, they go up, they do that spot repair. Now that same contractor might be working, as you said, on 5 different roads, but those are individual assignments and individual purchase orders that are being entered into, and so it's not a single project. Every location is different, and being at different locations under the public procurement statutes and the County Purchasing Act essentially makes those all individual projects. And so only when one location would require more than $50,000 would you be required to bid publicly.
And the qualifications, you're looking at is that where you're turning they're bonded,
Right.
Whatever.
You'd be looking at their qualifications based on their experience, their available equipment, their bonding capacity, which is also indicative of their financial stability. You look at their insurance that they maintain, and you'd have the county listed as an additional insured on those policies for any kind of blanket contractual endorsement, so that if you enter into a purchase order for a particular road service project, it would be $2,000. You'd have $1 million in liability covered for any accidents that might occur at that location. That's the type of thing we're talking about.
So the contractor, he would have the insurance, or we would?
The contractor.
He would be covered under our umbrella, under our insurance?
No, he's covered under his own insurance, and the county would be covered under his insurance, so that our insurance would never come into play. And he protects and indemnifies the county for any damage or injury that's caused by his or his employees or subcontractors' own negligence.
Who will be responsible for verifying their insurance non-capacity insurance?
Road and Bridge. When we receive, or really it'd be anybody that the county assigns to be part of the selection committee or the commissioner's court if you want it to be. But whoever receives the proposals, whoever the county has delegated the authority to review and approve and qualify these companies when they receive these proposals, that's the individuals from the county who would verify that the insurance requirements that we've requested are being provided. And that could be you and me, and the county judge, it could be all of y'all, it could be anybody who the commissioner court wants to delegate.
I don't have any questions. I completely understand. And I met with Mike on this also, so he said, I think it's great.
Okay.
I think it'll work.
You said we could make a motion on this
Yeah.
to,
It'd just be a motion on the floor to authorize the request and receipt of qualification statements from contractors for roadway maintenance projects. And we could move forward with that, and then if that motion was made, we reconvene or receive those proposals and have the court authorize the contract form we come up with and allow Road and Bridge and Mike to move forward with any of those operations.
okay, well, I'd like to make that motion.
I'll second.
Any other comments on the motion and the second? Been a motion and a second. Exactly what is the motion?
To go ahead and allow for pre-qualifications of prospective, I guess, contractors.
Right.
Yeah, contract agreements or whatever.
You're gonna draft it.
If you'd like me to draft a written motion, I'm happy to do that.
I would like for you.
Yes.
Okay.
Yes.
All right. All in favor of the motion signify by saying aye. Aye. All opposed, same sign. Motion carried. Is that everything with you, Jeff?
As far as I know.
Thank you very much. You're welcome to stay, but you might want to get out of here.
someone wants to talk to me in the hallway, so.
Thank you.
Good luck.
Thank you, Jeff.
Item 7 on the agenda, discuss, approve, disapprove the purchasing of a computer to replace one of 2 computers that operate the, I think operate is probably the words misspelled, it should be there, operate the NX video system. This computer failed and needs to be replaced. To be paid out of the IT 2014-2015 budget. The author of this item is Sheriff Dwayne Villanueva. Sheriff.
Judge, good evening. The computer system that we have for the annex here that we video everything for security purpose, the computer needs to be, we need another computer. This one that we have now is just, it's out. The whole screen went out, we can't get it to operate.
Crash on?
Yeah, just crashed, yeah. And I don't know how long it's been there, but you can tell it's been there a while.
Where's the surveyor?
The whole annex, yes, the hallways, the front of Calvert Street, and here on the side, yes, sir.
Interior next.
Yes, sir.
But can we use the funds out of the security fund for the courthouse?
I'm sure you can, we can, if it's for security purpose.
Instead of taking out of the IT budget, I mean, maybe it's no big deal, but I'm just asking because it's more for security.
Yes,
than anything,
yes, sir.
huh?
Yes, sir.
I mean, so that's just my question. Judge, can I want to answer that question?
I'm sorry,
Yes, we could take those out of this courthouse security funds. Lorraine called me right before this meeting and she had been reading the agenda and she asked to be sure that whatever is purchased is compatible with the new camera system that will be installed based on what was budgeted in this year's budget.
Okay, so then we
At
can,
the jail, you talking about?
the same.
Right. We budgeted for the new one at the jail, we budgeted for one at this building, and we budgeted for one at 200 East Calvert. So whatever operational system is acquired needs to be sure to be compatible with the new system.
Okay, I can get the rest of the jail system.
We can call her and then make contact with the individual that's gonna do the computer
So
system.
that's what I'm saying about the security fund, that's exactly what it's about. It's for the security of this courthouse, of this building, inside and out. And, I mean, IT is either way, it's just the same, but to me, I think we've got some funds that we collect for the security issues, so we should probably use them.
Sure.
And all I'm asking is we need to replace it as soon as possible.
Any further,
I'm not sure we need to make a motion.
I think probably,
It's not requiring type of a budget amendment, is it? No.
it's going to be paid out of the IT budget, which is what you're asking.
Security.
Out of the IT or for the courthouse security fund?
Well, the item says be paid out of the IT, but probably, I don't know if that's.
I think if you just amend or state your motion to include
Well,
courthouse security.
Courthouse security.
yeah,
Courthouse.
yeah, and my motion would be to use the courthouse security fund to pay for the replace of this, piece of equipment that hopefully will be compatible with what the new system will be.
I second.
Is there any other discussion? All for the motion signify by raising your right hand. All opposed, same sign. All voted for. Motion carried.
Thank y'all very much.
That's the last item for action that's on the special call meeting. Item 9, to convene the workshop, convene the special meeting into a workshop. And the workshop will just be a discussion matter. There'll be no action taken for anything, but we need a motion to adjourn and
I'll make the motion to adjourn the special call meeting.
any other discussion. If not, all for the motion signify by saying aye. Aye. All opposed, same sign. All voted for. We will adjourn convene the workshop and go to the only item on this is the discussion of the possible hiring of 2 full-time employees for the county treasurer's office. Annual salary for each employee is presented at $31,328.31, along with the purchase of 2 new computers, plus installation, phone service, desk, chairs, and supplies for each employee. The remodeling of the supply closet at 200 East Calvert for workspace for the new staff. The remodeling would be done by the maintenance department. Total request is estimated at $72,156.62, ordered by Malone, and I would say before Sid said, the $72,000 is not the total request, that's the total amount for the annual salary for 2 employees apparently, and the purchase of all the equipment would be another.
Is that with fringe and all?
That's not so. That's what it looks like it says to me. But perhaps that's not what you meant. We're in a discussion thing we can discuss.
31 and 62.
Yeah, if 2 employees would be $62,000.
Okay, all right, 62,000, that is, but does the $10,000 cover the other cost?
I think when the original budget item I had put in there was the 2 salaries, the $2,000 for the remodel, the $2,100 and something for the 2 new computers, telephone equipment. I'm sorry, I didn't bring it with me. Trying to go else I had on the agenda.
We're in a workshop, if you can run down right quick, it's just one block, you don't have to run far.
Erica, can you pull up the agenda from last, she's on it. Is on the agenda, I specified the dollar amount for the 2 salaries, the remodeling of the supply closet. Zane and I visited with that, and I estimated like $2,000 for that. And he actually, we looked at it and he said it would probably be less than that. Computer equipment, telephone equipment. And I probably didn't put the.
Did
We have a contract that's been signed and it's in the abstract office.
And the earnest money check was delivered.
It was.
What about the office there where the special project used to be, you know, outside your office, you had those two little cubicles and one?
That is the supply closet.
Well,
I'm new to the court and I don't know what the building was purchased for. I thought maybe a swimming pool. It has the water in the
Well, they were gonna
basement.
put IT and,
Well,
HR and.
did the commissioners vote on it or this
Yes.
is, they did vote on who was going?
No, we didn't vote on who we were gonna put in there, but we voted to buy it for that reason, I guess.
It hadn't been decided who was going in there or how to be divided. Yeah.
Well, who's going to make the decision?
The court?
The court, it seems to me,
Yes,
but we haven't gotten that far yet,
Yes.
is what y'all are saying.
yes.
So, all of anybody that says they're moving over there is not as of right now.
Not yet. We haven't put anybody in there.
And then nobody's appointed to make assignments of different offices or anything. Okay. Don't anybody grab your office until the commissioner's court works on it. Because you might not be the one in that particular office.
so you have one new hire right now, correct?
Correct.
And you want to hire an additional two?
Yes, sir.
And what would they be doing?
Part of what they're gonna do is help me be able to do my statutory duties. We have Elaine, who is my new staff now, her main job is going to be payroll. We have 188 employees now, and once the sheriff's department gets through hiring, we're gonna have over 200 employees. That takes all of your time.
Well, let me ask you a question. You said payroll. Okay, is payroll a statutory duty or just to issue the check for the employee?
It's
Because
not
what I'm
under
saying is, excuse me, I'm interrupting, but what I'm saying is, if we hire the CFO person, I would think that person could have a payroll person in their department that would take the money in, I mean, the hours in, and make sure that they're correct, and then forward the information to you or to the auditor for final review, and then that way that'd be a person that would be in another department, but would be in there under, have to be under
to
you.
stay under the treasurer's department.
It's just to write the check for the payroll, right?
I'm still gonna have to verify it because before I put my signature on something, just like when,
Well, I understand. What I'm just saying is, but another person could outside your office could actually put the payroll together for y'all for final review. That would eliminate some
not
work for you.
necessarily, why would you wanna put somebody else in another department that's gonna have to come through my department for verification anyway, so you might as well put that person under me.
I was just thinking that another person outside would kind of lessen the load off you a little bit.
Well, that's what Elaine's for. That's what her
So,
job is.
okay, she just gonna do payroll.
Yes.
What the other person gonna do?
We've got quarterly reports that have to be done on state and criminal fees, 941s, unemployment. We have monthly, at least 28 bank statements a month that need to be done by myself. We take monies in daily, not necessarily daily, but from all 4 JPs, county clerk, district clerk, tax office. 2 or 3 times a week, deposits need to be made, fund transfers need to be done. Payroll is done bi-weekly, monthly reports, TCDRS. We have to move funds from the general fund to the county district clerk fees, the JP court fees.
Some of the reports, should they be done by the HR person that would be out of your department?
No, because that's money that is due to someone else, and that's part of the treasurer's duty, is to pay money to other people that are due. That's part of
Because I've called around different treasurers and just to verify how many people they have, and most counties have 2. And that's because they have considered an HR person and then a payroll person, and then the treasurer does the other stuff.
Okay, so the tax office has 4 full-time and 1 part-time and 1 seasonal. The auditor has 2 office. county attorney has 3 full-time and 1 part-time, and is going to get another victim service person. I'm not sure if that's full or part-time. JP1 has 2 full-time, JP2 has 2 part-time, JP3 has 2 full-time and 1 part-time, JP4 has 1 full-time. County clerk has 5 full-time, district clerk has 3 full-time. So why do they get to have those many people? And you're only
I'm glad you have that
two
much time to
full-times.
figure out who's got people working.
I have lots of time, Shelby, just twiddling my thumbs. I was here till 7:30 last night.
Okay. I just don't have a problem giving her
On
one
Sunday,
additional, I don't have a
works.
problem giving her one additional person to make it a total of 2, but if we're
I'm saying my
if we're
office-
gonna hire a CFO person, what I'm saying is gonna do some HR work, I really think we need to look at where we can, I don't want, I know we can't do anything with her statutory duties, those are given. Now, I don't know how many reports are actually, or that she's saying are actually statutory duties, but, and I know a lot of stuff is all generated by computer, as well as the material that's put into the information that you're trying to retrieve later on. But this what I'm saying is that we're gonna hire a CFO person, which is gonna in turn take the HR person. I'm not sure that we can take some of those duties, not her statutory duties, but some of the ancillary duties that the court may decide to do, and use other people outside the department to streamline her department.
You're not putting my.
I think 2 people is enough in that department, my personal
No.
opinion.
I think we need 3.
Okay, first off, as far as the question as to how much the possible hiring of these two full-time employees might cost, the $72,000 for the total is way under, because just the salary and fringe for 2 new full-time positions would be over $80,000. I want to remind y'all that in the budget that 4 out of the 5 of y'all adopted, you created 2 new positions, the CFO position and the assistant to the CFO that would be in charge of HR. HR includes payroll, and at the time that all this was discussed, it was discussed to take payroll and investments, which are non-statutory duties, out of the Treasurer's Department to lighten the load in the Treasurer's Department.
Payroll has to stay.
No, it does not.
Well, that may be your personal opinion on it, but you look at the Attorney General's opinion on it, and it cannot be given to an appointed official. It has to be an elected official. That's the Attorney General's opinion, which I know, Judge, you weren't here at the time that was presented.
I could read, if you'll bring to me the AG's
Okay.
opinion that says that,
Yes,
I'll
sir.
be sure that I read it and that the other court members do also.
Yes.
And if somebody can't, we'll get somebody to read it to us, get it to us,
Okay,
if you've got something that shows
Yes.
that.
yes.
I did talk to a treasurer in another county, and if I'm not mistaken, I was told that they have an accounting firm do payroll and the treasurer verifies it.
It would be quite similar to the way we do it now. A department or individual within the county would do the payroll. Vi would have first review of it, and I would have final review of it. If there are errors found, it would go back to be redone just like it is now. But again, as I was saying, y'all set the budget to include these 2 new positions. We need to get those filled and let them do the duties, and possibly between the time that we can get those positions filled, I could possibly understand temporary help in the treasurer's office, but when you're going to be taking away a bulk of the workload in that office, I don't see where 2 new full-time positions
You're
are
not going to
needed.
be taking away the bulk of my duties. And someone who has 2 full-time people in her office shouldn't be having an opinion on whether or not I should have 2
That doesn't
full-time
anything
people.
to do, her office and your office is not the same.
Right.
You
Okay.
know that.
Right. And I am asking you to have 3 people in my office. Full-time people, not temporary people.
We understand that, I think. This is a discussion matter at this time, and we're not going to take any action on it today. But be sure, all of the court, that you've got your questions answered that you want from the treasurer.
Well, do we even have job descriptions for the
Have you prepared it?
That's
or
not,
anything?
no, from the chief
That's
financial
not your
officer.
job.
That's not my job.
You're doing other things that are not
Correct.
your job also.
Correct.
And nobody has prepared them. We've got two, I have one 28-page deal for hiring one of the jobs, which I'm going to throw in the trash. If it takes 28 pages to say what they have to do, I don't believe we're going to pass it here. And that's just a comment.
You have some candidates lined out already?
The ones, we did 5. Shelby and I interviewed 5, and there's 3 that, obviously, others, I'm not sure if they're still interested in the job or not.
And so, when you're a new person, if you've had them sworn in and everything, they're bonded and all?
No, we're waiting on her bond to come in, yes. Terry Frater's been working on that.
By who interviewed them? You?
I'm sorry?
Oh, you interviewed?
Yes, because when the original budget was, there was nobody in my office. They took my full-time help out, and my temporary help that I asked for was taken completely out of the budget. So after the first of the year, or the new budget year, then Judge Butler put it back on the agenda. And so he wanted someone to begin the interviewing with me when I did, and Shelby had agreed to do that. So there was 5 out of the 10 or 12, I think, of the applicants that we had gotten that we felt were qualified. So there was one that we actually had offered the job to, and she turned it down, and then the second one did accept it. So there's 3 others that I interviewed that may or may not be interested in it. It's just, we've gone from $5 or $6 million to 35 million plus. We've gone from 100 and something employees to 188 employees. I think the HR person needs to be under my office, not under the chief financial officer's office.
That's not a statutory job.
I know, but
in your office.
I know, but this is my opinion.
Okay.
This is what I think it needs to be. Payroll cannot be, of course, Attorney General's opinion, cannot be sent to an appointed person, has to be an elected person. It's the Attorney General's opinion on that. I think outsourcing it would probably be more expense than what it would probably be. It's something we can do. I just need more help in that office. We are all busier. If more business is coming in, more money's coming in. If all the JPs came in and asked, or no, I don't think JP4 asked for more help. If the other JPs asked for more help, that means that money eventually is going to come down to my office to be handled. So the more hands that we have in there to do to help me even do some of the reports that I do, or some of the other things that I do, would help keep the books straight, because that's what the main concern is. To make sure everything is straight. That'll help me stay on top of everything, help me keep money's receipted in correctly, and everything else. I mean, I'm asking for help.
I hear that. I've not been on the Commissioner's Court until recently.
Correct.
How many times did you make this request from the previous court before?
During the original budget, I asked for a part-timer.
For a part-time
yes.
only?
Well, I had a full-time position in there also already, but apparently people decided I didn't even need help at all, so they took it out of the budget.
Okay.
Do you have, so you plan to, just so I understand your core functions are you receive the money, disperse the money, you apply the money to the right funds, and then you issue payment once it's done, correct?
Right, well, the dispersing of the funds, that's
So-
part of those
so-
quarterly reports.
How does your other person that you plan to put in work, or 2 people, whatever the court decides to do, what will their duties actually be? I mean, other than you'll have one you're saying right now is for strictly payroll.
Yes.
But are you going to allow them to make the deposits and do other
They
stuff?
can
Or
receipt the money in, they can do filing, they can help be my second set of eyes when I come and do those reports. Because like with the quarterly reports, it's from all 4 JPs, county clerk, district clerk, the sheriff's department. It's legal size spreadsheet from all 3 months for each quarter. I go through it, I give it to Luana for another set of eyes to go through it. It just helps me keep up with that instead of me doing it. Like come January 1st, start putting that in. That person can, every time those JPs bring their monthly reports in, just automatically put it in. Then at the end of the quarter, total it up. Of course, filing on there, helping write disbursement checks. Someone needs to, when the auditor's office do the accounts payable, before I sign them, they have to verify that the dollar amount is actually what's on the bill and the vendor is correct before I sign them. Then somebody has to stuff the envelopes. That's something that another person can do besides myself or Elaine. There's plenty of work to keep two people busy. And I've been the only investment officer since I've been here, since 2007. Nobody else has stepped up to the plate to try to do it. I don't have to be the only person to do it, but I've been the only person to do it. I take 20 hours extra credit every year in order to keep up that certification. All 5 of you commissioners, 4 commissioners, the judge, the auditor, county clerk, district clerk, county attorney, anybody else can be an investment officer. It's not just signing a piece of paper and going off and doing it. You got to know what you can or can't invest in. It's not real complicated, but you got to know what you're doing. And I've been doing it.
Will your people be able to generate different, I mean, quite frankly, when we get our our treasury report, to me is kind of, I don't know, it's hard to read half the time. And I've looked at different other counties, maybe it's the computer program that we have. I've looked at other counties who are more transparent in what our reports are.
That's what our computer system generates.
Will the new Tyler be able to do it?
It's going to be the same report.
What, can we make changes to it?
It can be more detailed.
No. And will your person also be able to put the check registers on the website like we're supposed to be doing stuff
Yes,
like that?
all we got to do is scan those in and put them on there.
Because I think we haven't been doing that. There's some other stuff like that. So when do you plan to hire this person?
Well,
Or whatever?
of course, it's going to have to go in front of Commissioner's Court formally for approval. Hope by the first of the year we can get that all done and I can start. I would like to have a special meeting, but we're kind of running out of time for the holidays.
We'll get everyone Christmas Day, maybe.
That'll work. I'll be here Christmas
I'm
Day.
here and I don't have anybody living with me at home. I'll be happy to be here. I'm serious as I can be. I don't mind being here any day.
I'll bring a turkey leg.
Till midnight. I'll bring some stuff to work on
Okay.
that needs doing, is what it sounds like.
Whatever day you want to make it on Christmas, I'll be here with you.
Suits me, James. Let's just do it. We'll have a quorum.
Well, I'll be here watching on Christmas Day. I don't
We
want anybody-
appreciate the company. We will.
If y'all are gonna plan a meal for Christmas Eve, I'll be here too.
No, no.
The day after Christmas.
No
Day.
meals. Everybody has to get on the scales and you and I need to be last or something. No, I'm not being critical. I need to be last, not you.
Judge, could I just ask one question?
Sure.
And this is nothing personal. We get all these people in there. I just have this impression we could put 50 people in there and we're still not going to get a decent report when it's time to be given. The books still aren't going to balance. Is there anything that can happen where the books can balance for a change? And this is before the oil field business when these books didn't balance.
There are a lot of things that can be done to balance books,
But that's what I'm saying.
whether we can get anything done here, we'll see as time goes on.
The
I
court,
would hope so.
the court is obligated to provide the treasurer with I guess the help she needs to do that. That's one of that's per statute, correct, right?
Right.
Now, I think the difference may come into question is what do you consider how many you need, is it 5 or 10 or 3 or 2 or whatever, you know. And then again, I know times have changed. I just looked around and most of the counties with pretty much the same income that Karnes County has in their treasurer's office have 2 people in addition to the treasurer. And that's some of our neighboring counties. And some counties actually have a bookkeeper that comes in and does all that stuff for them. So, I don't know.
That might answer the question.
Says, what confidence can the public have in fiscal structure of the county government? Texas county government is structured in a manner which requires county financial undertakings to be open to the public and within the actual and official knowledge of more than one elected official. County treasurer, integral part of this system of the internal controls designed to prevent excessive concentration of power in one official. The dispersion of public fiscal duties and among several officials assures an orderly and honorable administration of public finance in ways which inspire the merit of public trust. I guess that's it, huh?
Yeah.
Somebody want to keep that from me.
Right, with the addition of help that you're asking, the books will all be straight.
Yes, they'll give some of the other things that I do within my office, gives me more time to concentrate on that, yes.
What kind of time period would you figure that they would all be straight?
Oh, I'm not gonna,
Oh, it could
I'm not gonna obligate myself to that.
Okay, I was just
It's
asking a ballpark.
Every day, if I can, some of the I was here last night, till 6:30, helping 2 people retire. I stayed another hour. Sunday, I was here Sunday. This Sunday and the Sunday before.
Yeah, I know you're here, I see you, I'm right next door. And I'm sorry for that question about the time frame. I was just, I didn't know if 3 months, 6 months, a year, what it would be. What I would ask.
I guess I just don't want to, I want to provide Val what she needs to do her office, but I don't. My concern is, I think we have to really be careful that when we create the CFO thing, that eventually we don't end up having an office that's overstaffed and that we may need to have to move that person out but then she doesn't work for us, she works for that person. Works for Vi or whoever the person would be. I just don't want to I just want to make sure we get our finances in order and I want to make sure our employees are taken care of with the HR and stuff, make sure our time clock issues are correct and find that we're doing the right thing, they're getting their proper amount of money they're supposed to be getting for their work. It's a lot of little things, but I know for now though, I'm talking for me, I have no problem right now providing one extra person until we can see what we can get out of that one person versus anytime in the future we'd have to increase it later on, but I think we need to take baby steps first before we start doing a major change without our CFO person in charge and working in their department and HR and however we're going to do this.
Where would the money come from for whomever we authorize?
There's the unencumbered fund that was put in there of $250,000 from what I understand. When it was put in there, Judge Butler said it could be used toward paying people extra, etc. And that's where the salary for Elaine is coming from now.
It's a contingency fund, it's not unencumbered
I'm sorry,
funds.
contingency fund, excuse me.
Is not unencumbered, you said?
Contingency.
Judge Butler specifically put a line in the budget this year for contingency items of $250,000.
That is unencumbered.
It is not obligated except for the treasurer's assistant and the benefits for the current position.
That has already come out of that fund.
Yes.
Is that closet that you want to remodel That's where the special projects was?
Yes, yes.
So y'all don't have another storage closet anywhere in that office, correct, in that building?
No, and in my personal opinion, when you order your supplies, you need to come get them. We shouldn't even have a supply closet with all the extra supplies. Whenever the departments order them, then they need to come get them. There shouldn't be anything in there.
Maybe each department needs to start ordering their own stuff and we're shipped to them directly.
It's also not just office supplies for departments. We have files stored in there. Our most current previous fiscal year 14, is stored in there until it can be removed to upstairs. Will not take place until after we've finished our outside audit, which won't be completed until probably the first part of March. So almost a third of that closet is files from the county auditor's office from last fiscal year.
And they can be moved upstairs.
Has the audit started yet?
No, sir, they are scheduled to come the week of January 26th to begin.
To begin?
Yes, sir.
Audit for 13, 14?
Correct.
That's the year?
The same auditors, ABIP. They are not on a contract. When they gave their bid, they bid for 2 years. But they are not on a contract. We sign an engagement letter when they start the audit. You have to, if you want to change auditors, you have to start that process in March or April because they book their schedules way far in advance, and there are very few auditors out there that will do governmental audits anymore.
Wilson County's in the process doing theirs right now.
Their audit?
Cost them, I think, you said $19,000?
Shelby, I appreciate the offer for the one, so what if we do one full-time at the $31,000 and we do a part-timer, say $12 an hour that comes help, 20 hours a week, just filing. Just filing. I mean, that takes, every time somebody brings in a report, we get a copy of the report, you know, JP's come in with credit cards, we've got to get somebody to reconcile the credit cards. I mean, that'd be something that somebody can do on a part-time basis, 20 hours a week.
I mean, that's the court's position, where we go that to a meeting, put that to a meeting, and something for the court to think of. I appreciate that.
Any other comments or? Is there anything else that, or nothing else on the agenda?
There's nothing else?
So, okay. Motion to adjourn.
I'll make it.
I'll second it.
All for adjournment, stand up and leave.
Thank you.
I'll consider that an aye vote.